Further hearing in the appeal, the Queen against Chaytor and others.
Mr. Fitzgerald, you're dealing with what has sometimes been called exclusive cognizance,
yes,
which covers a different area from Article 9,
yes,
an overlapping area. But it covers, does it not, all areas of activity within Parliament, to the extent that if the police are considering an investigation, they can't just walk into Parliament and start investigating. I've been considering the Police and Criminal Evidence Act and the very detailed provisions that it makes in relation to the powers of the police to obtain evidence. Does any of that apply in Parliament?
I'm sorry, I will have to check.
Yes.
Have to check that. But the only the two issues I can help with the tripartite agreement, which is part of Part 5, which I'm going to right now.
Yes, yes.
And I can help a little bit in relation to the case arising from Damien Green, where there was a dispute, in fact, between the Speaker and the Metropolitan Police Commissioner as to what the proper protocol was.
Yes.
So it's not all, as it were, plain sailing, as my learned friend Mr. Lord Panic suggests, that there was a dispute arising out of the Damien Green case as to the protocols.
But what was occurring to me is, in a case like this, there can't realistically be any question of a prosecution without considerable assistance moving from those within Parliament. Otherwise, how can the police get any evidence at all?
Yes. Well, certainly there has. I mean, in this case, I think that there was cooperation.
Yes.
Indeed, the papers were turned over.
Yeah.
My Lord, what we say Parliament has reached is, as it were, a pragmatic approach, which is that they will defer to the police in an investigation. The result being, with the exception of the Damien Green case where there was a dispute, with the result that the point then has to be taken before the court. That's the first stage. Or, I suppose, one could have a judicial review at the instance of the MP of the police action or of the initial appearance. But what we respectfully submit is that there has been no waiver by Parliament as a whole and no concession by Parliament as a whole that the doctrine of exclusive cognizance doesn't apply.
Sir Justice Saunders, in paragraph 21, this is pages 39 and 40 in the appendix, did seem to proceed on the basis that there would be cooperation with the police inquiry, indeed had been, and with the court in these proceedings. Is there any reason to doubt that?
No, my Lord, we accept that there has been cooperation in the sense that the papers have been provided and the materials have been provided by the House of Commons.
Yes, and as far as the defence is concerned, you've not met with any obstacles so far in obtaining what you need to do for defence purposes, have you?
No, my Lord. Yes. Yes, there are problems, I understand, in the case of Lord Hanningfield. Those issues are being addressed in the Lord Hanningfield case.
So your position is that it doesn't matter that the House authorities have cooperated, is that right?
Yes.
Because if there's a privilege, and that's it.
My Lord, certainly if there's a privilege, and there is authority for that. Well,
that's not rumour, what Wellesley was on.
By the New Zealand House of Parliament. They said we can't waive Article 9 privilege. So that's the position in Article 9. But even with exclusive jurisdiction, we respectfully submit that if there's an exclusive jurisdiction, I can't say it's not a relevant factor, the views of Parliament. But if there is an exclusive jurisdiction, then that exclusive jurisdiction falls to be determined once the matter comes to court. The court then decides whether, in fact, this is a matter that is within the exclusive cognizance of Parliament. So, if it's Article 9, you simply there can be no waiver. All you can do is change the law. If it's exclusive cognizance, we respectfully submit that again. If that is what the common law requires, that's what the common law requires. And the court would then say, as indeed Mr. Justice Morland said in the Hutfield case, this isn't an area that we should be entertaining as a criminal prosecution. Can I deal with the PACE situation in due course? Well, that really brings me on to your lordships have, my lady, have three things. The missing page 14, I hope, is there for insertion. Hopefully. So that concludes the submission that we say that the exclusive jurisdiction is not limited to collective decisions, but applies equally where, in this case, to the application for payment. That's at bottom of page 13 and the top of page 14. And then the final issue that I was going to address today is the issue of the position of Parliament. Before that, my Lord Phillips asked me about the powers of the House of Commons to punish for contempt, and we prepared a note slightly expanding the grounds of appeal on both the acts amounting to contempt and that's drawing on Halsbury. Unfortunately, the extracts of Halsbury that you have in the bundle are incomplete, so we provide you with a complete extract from Halsbury dealing with the nature of the offences. And yes, so it's really page 867 and 868 deal with what can constitute contempt, which includes, of course, a lying to Parliament. And then the question of punishments are dealt with from pages 878 onwards, the series of punishments: imprisonment, reprimand and admonition, expulsion, suspension. And we pointed out that there is some debate as to the existence of a power to fine. That's in paragraph 3 of the note. But could I just make this further point, that though the existence of a power to fine is controversial, there is a power, of course, to order repayment, which has been exercised as a result of the Legg inquiry and the Legg report. There is also a power to...
How is such a power enforced?
Well,
at all?
If you're a sitting MP,
yes.
It's enforced by a suspension or expulsion if you don't comply.
Well, and deduction presumably from salary or
Yes.
allowances.
And the other thing, if you're an ex-MP, they can withhold your resettlement grant, which is very substantial. And your lordships and my lady have at volume 5, tab 64, evidence that in the case of Elliot Morley, they have at least temporarily suspended any payment of his resettlement grant. And they could, again, in the case of an ex-MP, deduct from their pension. So there are quite substantial financial penalties or disadvantages that can be imposed by Parliament.
The pension is payable by Parliament, is it?
Yeah,
By the House
yes, that's
itself?
right. It is, yes. And certainly the resettlement grant is and the court can see at volume 5, tab 64, the withholding of resettlement, or the suspension of the resettlement grant payments to Mr. Morley. The payments have been suspended rather than withheld. This has been done only as a precautionary measure. And then the suspension of payment of any resettlement grant, as this is a decision taken within parliamentary proceedings, it follows that it is not a matter which the courts may determine. So, again, they're saying this is within our exclusive cognizance, this power, which is effectively the imposition of a sanction.
That was a decision taken by the estimate committee.
Yes.
Was it, or was it taken by the whole House?
It wasn't taken by the whole House.
Members' estimate.
By the members' estimate committee.
MEC.
Yes, yeah, one C's at the bottom.
Yeah.
And then the court has the punishment of non-members dealt with at paragraph 4, and at paragraph 5, the Joint Committee also observed that Parliament is better placed than the courts to assess the seriousness or triviality of the contempt. And I just draw attention to that quotation, that the balance between the freedom of the individual and the essential protection of Parliament involves considerations of a political character. Whether obstructive conduct can sensibly be overlooked or treated leniently or requires a tough response is a matter for the judgment of Parliament. So the court has that. Well, I'm going to try to conclude by 11 o'clock or shortly thereafter, so as to not all panic for sufficient time. So can I just take the court to the part 5? The Court of Appeal attached significance to the fact that Parliament had taken no steps to intervene to protect its privilege or exclusive jurisdiction. That's from paragraph 70 really to paragraph 72 of the Court of Appeal judgment. The Crown contends that Parliament, through its relevant committees, has expressly stated that it does not wish to assert privilege in respect of these matters. We don't accept that that's a fair statement of the position. There are two distinct issues. Has Parliament as a whole taken a view on whether privilege and or exclusive jurisdiction extend to cover MPs' claims under the ACA? And secondly, if so, has it, by its statements or conduct, waived privilege or waived its exclusive jurisdiction? And just dealing with the question of waiver first, at 5.2, we acknowledge that Parliament's exclusive jurisdiction exists for the benefit of Parliament. Accordingly, Parliament's clear indication that it wishes to waive its exclusive jurisdiction may be a relevant factor if it was given. But for the reasons that we set out below, we submit that it has not indicated that it does not have exclusive jurisdiction. The applicants further submit that Parliament cannot waive privilege insofar as it is derived from Article 9 of the Bill of Rights, without an Act of Parliament amending or repealing that provision. Can I just indicate...
Does that mean that if it's a common law exclusive jurisdiction, it can waive it, can it?
No, we respectfully submit it can't be waived.
If it can't be waived, what's the relevance of the indication that it wishes to waive?
Well, my lord, it's simply this, that if the Supreme Court has the power to determine whether a common law principle should develop in one way or another, in addressing that, I can't say that it would be totally irrelevant to look at modern laws. And in looking at those, the Supreme Court could say, well, one of the relevant factors is the approach of Parliament itself, if it had been clearly indicated. That's to say, I mean, if there had been a resolution of Parliament saying we've had enough of this exclusive jurisdiction, and then it came to be determined by your lordships, my lady, in the Supreme Court, the attitude of Parliament could be a relevant factor, because it being the exclusive jurisdiction being a creature of common law, and the common law being capable of development, I accept that.
So in other words, we would be changing the common law, not Parliament. We would be saying, given, on your hypothesis, given that Parliament now says we don't want to have exclusive jurisdiction, we shall reverse centuries of law and say it doesn't have exclusive jurisdiction. Is that how it works?
My lord, what I'm saying is it would be a relevant factor. I'm not inviting you.
But it will be relevant for the purposes of this court deciding that the common law should be.
Yes.
Is that right?
Yes,
or,
my lord.
Or shouldn't be declared to apply in that respect.
Yes.
Is that?
Yes. My lord, I have to accept that the exclusive jurisdiction, being a common law, a creature in the end of common law, and common law being capable of development, it would be possible. Obviously, that's not what I'm encouraging the Supreme Court to do, but it would be possible for the Supreme Court to say one relevant factor would be if there had been an unequivocal indication by both houses of Parliament as to their position. We say there hasn't been an unequivocal, but one relevant factor. I mean, if one looks at other areas where the common law is developed, the courts do look at, as it were, contemporary views, contemporary values, contemporary, but I'm not in the least bit inviting the Supreme Court to reverse, as your Lordship says, centuries of law. And I, in fact, respectfully submit that if it is to be done, it should be done by legislation which addresses the many difficult problems that arise.
So if it's by legislation, then that necessarily involves both houses.
Yes.
And that's part of the package, is it?
Yes.
You would have to see what the attitude of both houses were.
Yes. My Lord, our essential submission is this, that if the exclusive jurisdiction of Parliament, recognised over and over again in the cases which your Lordships and my Lady have seen the key references to, it is to be altered, modified, qualified, it should be by statute. That's our primary submission. But I can't say it would be wholly irrelevant if Parliament had unequivocally indicated a view.
It's not just a question of looking at contemporary views in the sense that one sometimes thinks relevant general public attitudes. It goes a bit further, doesn't it? This is a privilege which you said a moment ago is for Parliament's good. And presumably Parliament is best placed to know what is for its own good.
Yeah, well, my Lord, I certainly would accept it's a relevant factor. But the problem is this. Whether one takes, as it were, a snapshot of Parliament in retreat at one particular moment with the press howling at its heels, as it were, and says, they're in retreat now, right, we'll attach significance to the reactions of Parliament at this particular moment in time, or whether you say, no, there are more fundamental principles at stake that have endured over the centuries for good reasons, and those reasons still hold good. And the particular views of a particular committee or member should not hold sway against that constitutional bedrock, I suppose. But because, my Lord, we do respectfully submit that some of these are reactive statements by Parliament at a particularly sensitive political moment. I mean, some of the actions and statements were made with an election coming up.
I mean, one can suppose, can't one, that Parliament would have in mind as the sort of touchstones as to their attitude two things in particular. One, its reputation, and two, its necessary autonomy.
Yes. Well,
but I mean, aren't those considerations that we too should have in mind when we consider how far under the common law this privilege extends?
Yes. My Lord, yes. In the final analysis, this is a matter for the courts to determine, the exclusive jurisdiction. And we respectfully submit that if one looks at the evidence that is being adduced, Parliament hasn't protested, has allowed these matters to go ahead. Various clerks have made various statements at various times. That's not an unequivocal statement by Parliament that expenses claims are not within the exclusive jurisdiction. And that's the purpose of our analysis at Part 5. And but, my Lord, I totally endorse that the autonomy of Parliament remains a matter of crucial concern.
Can I just be clear? Parliament's jurisdiction is contempt jurisdiction. It's not disciplinary jurisdiction, it's contempt. Is that it?
My Lord is absolutely right, and it was a loose expression, I apologise.
No, I mean, the Court of Appeal used it in paragraph 47 in connection with the Ron Brown case, its own disciplinary functions. I mean...
Yeah, it's loose language. I accept as my...
I mean, it is right, is it? I just want help. I mean, it is a contempt jurisdiction, pure and simple.
It is, my Lord. If one looks at Halsbury, where they deal with the... perhaps it's best through this extract.
Sorry, where are we finding? We're going to Halsbury.
Yeah, your Lordships have handed up.
Yeah, I have.
Had handed up. If you look at page 867, contempts.
Page
867 of the paragraph 1083, contempts. The power of both houses to punish for contempt is a general power similar to that possessed by the superior courts of law, not restricted to the punishment of breaches of their acknowledged privileges. Any act or omission which obstructs or impedes either house in the performance of its functions, or which obstructs or impedes any member or officer of the house in the discharge of his duty, may be treated as a contempt even if there is no precedent for the offence, etc. And then acts amounting contempt. Among offences amounting to contempt are misconduct in the presence of the House or a committee of the House, deliberately misleading the House in a personal statement, refusing to answer questions as a witness before the House, disobedience to rules or orders, abusing the right to petition, presenting forged documents to the House, or conspiring to deceive the House, misconduct in the exercise of duties. I won't read on, but the Court can see there are an extensive list and extensive precedent for treating those forms of misconduct as contempts, subject to what we respectfully submit it is, at least in many cases, an exclusive jurisdiction of Parliament. We then take, if one's looking at it, then one sees jurisdiction of Parliament at 878, the proceedings against offenders. If a contempt is committed and cited by the House may proceed to punish. And then it deals with the various punitive powers, the power to commit, to prison at 1097, the period of imprisonment 1098, the reprimand and admonition at 1099, the power of expulsion at 1100, and the power of suspension at 1101. Added to which, of course, there are the powers, the more informal powers to withhold resettlement grants, pay, pensions, which I've referred to.
So, Mr. Vice-Chancellor, on the facts, it's your case, is it, that if they're proved against your client, there was a contempt of Parliament?
Yes.
Is that's your case, is
Yes.
that would be a contempt of Parliament?
Yes, it would
and
be.
Would Parliament have power to imprison your client?
Well, my Lord,
or not?
It certainly the power to imprison certainly has never been removed.
So, what's the answer to my question?
The answer is it would have power.
And power to fine?
Well, that is
What's your case about that? On your case, would Parliament have a power to fine?
My Lord, I think I can go no further than this. It may well have the power to fine.
But you reserve the right to submit elsewhere that it wouldn't. Is that right? Well, it is right, isn't it?
My Lord, because it's not clear on the authorities. I think all I can submit respectfully to your Lordship is it may well have the power to fine.
So you reserve the right to submit elsewhere that it wouldn't.
You'll indemnify
nothing wrong with
against an
that.
application to Strasbourg, will you, on Article 6?
Well, my Lord, can I take this matter under advisement for short? I mean, all I can say is that the authorities are not clear on that. My Lord, but it's certainly never been expressly removed, a power to fine,
or exercised since the 17th century.
That's right. Yes, I think it used to be additional to you imprisoned and fined at the same time. But there is clearly a power to withhold financial remuneration, which is tantamount to a fine, and obviously if your resettlement grant is withheld, that's
But that's not tantamount to a fine. That's recoupment of.
Oh well, I'm not sure that all the money's been repaid. For example, in Mr. Morley's case, but the resettlement thing has still been suspended, so it may be that it is being used as a form of penalty. Yes, it's operating as a penalty. I suppose they can say you're not the kind of person who we want to pay a resettlement grant. Exactly. So it is operating as a form of penalty. Because in Mr. Morley's case, all the sums that are in dispute, £33,000 in dispute, have been repaid. Nonetheless, his resettlement grant has been withheld. 60,000. Of 60,000. And so they clearly are contemplating that if an adverse finding is made either by the courts or by themselves, and they haven't discontinued, they've simply suspended contempt proceedings, the possibility of contempt proceedings against him. There's still an investigation, internal investigation against Mr. Morley. And they have withheld his resettlement grant after many, many years of service, and including as a minister. So clearly they think that there is a power to, I said, well, I suppose it's conduct unbecoming leads to, we're not going to pay you a resettlement grant. But, again, I wouldn't. So, well, my Lord, that's the situation.
Does that only apply to Mr. Morley?
No, I understand it applies to all three of you.
They've all repaid the money and this is being retained. Is that right?
Yes, I understand in the case of Mr. Chaytor, he hasn't repaid because there's still a dispute, but he has had his resettlement grant withheld, and then certainly, I think all three have had their resettlement. All three have had their resettlement grants withheld.
Yes, but the question is have they repaid? Mr. Chaytor not yet, or it's in dispute.
Yes, Mr. Chaytor has repaid.
Has or hasn't?
He has.
He's repaid,
Yes.
and yet his resettlement
Yes.
has also been forfeit.
Yes. Yes. Well, it's been. I think it's been suspended.
Suspended.
The resettlement grant has been suspended.
Suspended pending what?
I suppose pending both the criminal proceedings and any subsequent internal inquiry.
See the letter.
Because I mean, I would stress this: that it's not the case that it's, as it were, criminal proceedings or bust. These defendants all face internal inquiries which have simply been suspended pending the resolution of this matter.
Mr. Devine?
We're just checking that in 1 moment.
Mr. Fitzgerald, we've got in the passage in Halsbury quite a neat definition of the scope of contempt of Parliament in paragraph 1083.
Yes.
An act or omission which obstructs or impedes either House in the performance of its functions, or which obstructs or impedes any member or officer of the House in the discharge of his duty, or has a tendency.
Yes.
Now, I think it's accepted that not everything which would be a contempt is within the exclusive jurisdiction of Parliament. And the question is how, therefore, one defines the narrower category of privilege. And that's the difficulty. Is there a formulation which you can produce which bears some relation to this formulation in relation to contempt, but shows the difference?
Well, I mean, my Lord, just very briefly to revert to 1.1, Parliament has exclusive jurisdiction over the conduct and misconduct in Parliament of MPs acting in their capacity as MPs.
So 1.1
1.1 of the note.
Yes.
In their capacity as MPs, at least in their dealings with Parliament itself. And I think the formulation that the Court of Appeal recorded, just in case, I think, is any dealing a member has with the House in his capacity as a member.
Where's that, Mr.?
That's recorded in the Court of Appeal's judgment, as I think submitted at my...
Paragraph what?
Contempt covers non-MPs, for example, privilege. You restrict to. Well, the trouble is we're only talking about MPs in the present context, but privilege is surely not restricted simply to MPs. It comes back to the question: what different test would you be advocating, or would you be in fact advocating? In reality, exclusive jurisdiction over all contempts,
Well,
unless they involve some
interpersonal
physical injury or something.
Well, certainly, my Lord, the only exception that we see as a clear one is in respect of MPs is the question of interpersonal violence. So, I mean, I think the other concession made was if you gratuitously take out the gratuity, if you damaged a picture in the House of Commons, just my own friend Mr. Fleming gave that example. If you just went and slashed a painting, that would obviously be covered.
There's no equivalence, is there, between the power of contempt, the power to commit for contempt or punish for contempt, and privilege, and exclusive jurisdiction? For example, it's a contempt to impede a member on his or her way to Parliament. So if you falsely imprisoned a member in Tavistock Square, it would be a contempt, but it would also be punishable under the criminal law, and civilly, the person would be civilly responsible as well.
Yes. Yes, my Lord, I accept that. We don't say that if it's a contempt, then it necessarily attracts the exclusive jurisdiction. We do say that if it involves the relationship between the MP acting as an MP and Parliament itself, then that is a matter, what's described in the exclusive jurisdiction case as an internal matter over which Parliament has exclusive jurisdiction. And one of the reasons why it has exclusive jurisdiction is because it has the power to punish for contempt. But your Lordship is right that we can't, as it were, say neatly overlap or coincide the two jurisdictions.
If someone presented themselves as an MP, forged documents, I don't know whether these claims can be done. They probably can in a purely documentary way, and extracted in that way a lot of money from the fees office. That would clearly be a contempt. But on your formulation, because he wouldn't be an MP, it would be punishable as a criminal offence. So it's merely the fact that the person is an MP. And
certain acts of strangers would just be susceptible to the normal processes of criminal law, although they would also constitute contempt. I mean, extracting money wrongly from Parliament would undoubtedly be a contempt also, but it would probably be dealt with by the ordinary course of
Well, as Mr. Gibson was dealt with in August of this year for that very offence. On a plea of guilty, as I understand it, to extracting money from the same fund from which your clients obtained their payments. And he was an officer of the House, an officer in the fees office.
Well, my Lord, we certainly...
you don't say that he was wrong to have pleaded guilty, or that the only jurisdiction was in the House to deal with him, do you?
My Lord, we certainly don't make... it's not a necessary part... Can I put it this way? It's not a necessary part of our case that he was. It may well... I'm sorry to sound evasive, my Lord, but one is treading on an area where I haven't actually thought through the consequences of that. But we do respectfully submit that is distinguishable and isn't covered by our test. But if I can then take the call back to the short indications, it may well be that I can take this quite shortly. That there's firstly Malcolm Jack, the Clerk of the House, made these observations, and that's at volume 5, tab 57, and he simply said that although, and that's in September 2009, he says, although I accept the ACA scheme arises from the resolutions of the House, the proposition that all actions or claims under it are proceedings seems to me unsustainable. The House agrees to many things by resolution. That does not mean that all activities in connection with its erection are proceedings. Proceedings must imply, in the words of the Joint Committee on Parliamentary Privilege, formal collegiate activities of Parliament, rather than merely the consequences of the decisions that either House has taken. And we respectfully submit that this is, although he doesn't refer explicitly to Article 9, his emphasis on the term proceedings suggests it is this rather than the broader principle of exclusive jurisdiction to which he refers. In any event, we submit this is no more than Mr. Jack's personal opinion as to whether privilege extends to expenses claims, rather than a suggestion that privilege or exclusive jurisdiction has been waived. He does not purport to be expressing the views of the House or to speak on anyone's behalf other than his own. So it's merely a view which the Court is obviously has the power to take into account, but it doesn't represent the view of the House. The second matter relied on by the Crown is the Sir Philip Moore, the then Parliamentary Commissioner for Standards, his observations in 2003. Those arose in the context of the Michael Trend case, who was claiming for overnight expenses when he didn't stay overnight, and he in fact was dealt with internally and by suspension for 2 weeks. The court has that at tab 50. The report of the Committee on Standards is the first item at tab 50, and if the court looks over to the second page of that, one sees paragraph 17. Having weighed all these considerations, we recommend that Mr. Trend is suspended from the service of the House for 2 weeks. Essentially, they found, I think, chaos rather than dishonesty, and suspended for 2 weeks. And then one sees Sir Philip Moore's finding. It's at page 6 of 7, paragraph 46, where he says that the decision whether Mr. Trend or any other member who may be shown to have wrongly claimed Parliament should face a criminal prosecution is one for the police and the prosecuting authorities, not for me. As the briefing note on the law makes clear, there are a number of ingredients, and then he makes the
6 of 7 in the same thing at the bottom.
yeah, it's 6 of 7 at the bottom.
Sorry, yes,
And it's 46.
So one sees that, and then the claiming of allowance is not a proceeding in Parliament. The provisions of parliamentary privilege do not apply. Members are no less subject to the criminal law in this respect than anyone else. We make these submissions. This was an assertion as to whether privilege extends to the submission of expenses claims, not whether Parliament had chosen to waive it. It was an opinion of the Commissioner made without reference to the case law or the relevant legal principles. His background is civil service, not law. And thirdly, his opinion was neither accepted nor rejected by the committee itself, which made no reference to this observation. And as the court has seen, what in fact happened in that case was it was dealt with internally and dealt with by way of a suspension for 2 weeks. See paragraph 17 of the third report. The third matter that's relied on by the Crown is the tripartite agreement, which you have at volume 5, tab 52. That arose out of the Conway case, the Tory MP Derek Conway being accused of favouring his sons by paying them as research assistants in his constituency, and there was a dispute with the Metropolitan Police Commissioner expressing frustration that the chairman of the Standards Committee had not referred the matter to the Metropolitan Police. Then there was a meeting, and the meeting, one can see, is referred to at tab 52. So one sees the complaint system in the criminal law. Following publication of our fourth report, we asked the Chairman and the Parliamentary Commissioner for Standards to meet the Commissioner of Police to discuss matters relating to the handling of complaints against members. It might also raise questions of criminal liability. And then there was an agreement that one has at the appendix there, and the key passage, I think, relied on by the Crown is all parties agree. This is the second paragraph of the appendix. All parties agree that other than the limited context of participation in proceedings in Parliament, members of Parliament are in no different position in respect of alleged criminal behaviour than any other person. The Chairman reiterated the committee's belief in the general principle that criminal proceedings against members, when these are considered appropriate, should take precedence over the House's own disciplinary proceedings. The meeting discussed how the respective parties might coordinate their activities to ensure the effective delivery of this principle. And then one has, where the Metropolitan receive information which suggests that a member of Parliament may have committed a criminal offence, they will take the decision on whether to institute inquiries. And again, Parliament, in the form of a commissioner or the committee, would refer matters to the police if they thought it appropriate. Obviously, that covers the whole gamut, from offences of bribery that wouldn't be covered by exclusive jurisdiction, assaults, and matters unrelated to either the exclusive jurisdiction or the parliamentary proceedings. And we submit that the effect of the agreement is that criminal proceedings should take precedence in those situations. It's an agreement reached as guidance between free individuals, although we accept that the chairman of the Standards Committee was acting on the authority of the Standards Committee, and really it just postpones the question of privilege under Article 9 or exclusive jurisdiction until the actual trial, at which point it is raised.
What is the code of conduct it's been referred to?
Oh, that's the code of conduct for MPs, which I think was issued by. Was that as a result of Lord Nolan? Yeah, I think it was, there was a code of conduct issued.
What's relevant? I mean, he's talking about alleging breaches of code of conduct. I mean, that's what the context of this seems to be.
Yes.
The first paragraph on that page.
Well, so if there is misconduct which is covered by the code of conduct which was issued as a result of the Lord Nolan's inquiry, then they may also raise issues of criminal liability, such as, I suppose, dishonesty. Or
the code of conduct would embrace such things as bringing the house in disrepute. I mean, it would encompass assaults and damaging pictures and all the other things we've been talking about.
Yeah, absolutely. Yes, it embrace the whole gamut, including financial misbehaviour and including, I suppose, insulting behaviour, interpersonal violence, the whole lot.
Is a breach of it contempt?
Yes, I mean,
there are lots of things in the codes of conduct for judges, but it doesn't necessarily follow that they would be dismissed because they failed to live up to them.
No, I appreciate it.
I'm just asking, what is the status of this code of conduct, and what relevance is it to contempt? How does it bear it?
Well, I suspect that, as your lordships observed, some of the things in the code of conduct would also, a breach of some of the aspects of the code of conduct would constitute contempt. Some of them may be more aspirational or best practice in terms of, and they might not constitute a contempt.
Have we got this code?
I'm not sure that it's in the bundle. No, I'm not.
That's what they seem to be talking about here.
Yes. Well, the long and short of it is we respectfully submit this doesn't answer the question. This is just a procedural agreement which begs the whole question. Yes, but what is parliamentary proceedings and what is exclusive jurisdiction? And that issue is simply postponed until it's raised in the court by someone who says that this is inappropriate. Because I am governed by parliamentary proceedings or I am within the exclusive jurisdiction. I think my learned friend, Mr. Panic, has handed us this morning something where recently, in accordance with that tripartite agreement, Mr. Dennis McShane has been referred to the police by the Commons Standards Committee. I understand the complaint was made by the British National Party of wrongly incurring expenses in relation to investigations of anti-Semitism in Europe. But that's how it all arose. But that perhaps indicates that some of these complaints can, at least in origins, be very strongly politically motivated. And the only other further point we'd make is it's not as if this tripartite agreement has solved everything, because following the tripartite agreement we had the Damien Green fiasco, in which very different views were taken by the Speaker and the Metropolitan Police Commissioner as to the extent of the powers, and the Metropolitan Police Commissioner wrote a letter saying to the Speaker saying, I don't agree with your protocol. So it's not as if the respective areas of competence have been resolved without any controversy. My lords, my lady, can I then the Legg report? My learned friend Mr. Plemming has already referred to that. The Crown suggests that the terms of the Legg report also supports the proposition that Parliament has expressly stated that it does not wish to assert privilege in respect of the applicants. And I think my learned friend Mr. Plemming did take you to it. It's at tab 60, the Legg report, and the key passage is at page, I think the simplest way of looking at it is at page 5 of the main report, the ACA review, at paragraph 8, under the heading Executive Summary on page 5, going down to paragraph 8, my review was excluded from dealing with issues under investigation before the 20th of July 2009 by the Parliamentary Commissioner for Standards or at any stage by the police. So he was directed to disregard those matters, and we say that's simply consistent with the tripartite agreement referred to above. It doesn't undermine the applicant's case. It's a recognition that the police initially take precedence, but again, that's subject to the court's ruling on exclusive jurisdiction and Article 9. And finally, the Crown rely on the 1999 Joint Committee on Parliamentary Privilege, which is Volume 5, tab 49, where the Joint Committee expressed the view that resolutions or orders governing members' salaries are proceedings in Parliament, but their implementation is not. My learned friend, Mr. Fleming, took you to that. We make these points. The committee did not express a view as to whether the submission of expenses claims fell within parliamentary privilege or Parliament's exclusive jurisdiction. And in the same paragraph of its report, the committee recognised that the boundaries between matters within and without the scope of privilege are not tidy. And we do submit that the committee's comments do not provide a broader indication of the scope of privilege. We make the point that resettlement allowances are held to fall within the scope of privilege, you have already seen what the clerk of the Members' Estimate Committee wrote to Mr. Morley, saying that payments do fall within the scope of parliamentary privilege and therefore cannot be susceptible to judicial review. And our conclusion...
Should one not add to this list of indications of Parliament's views the Speaker's statement of the 8th of February?
I accept that, my Lord. I should, yes.
It's in...
yes, it's in the...
Tab 62 at page 7, it's reported.
My Lord, I accept that. I think it's... it would be helpful. Yes, it's at page 5, I think.
Well, it's page 7 of tab.
Yes, absolutely, yes. I wish to make a statement to the House at page 7.
It's the last few words of that.
The matter is therefore before the courts, and the House and members would not wish to interfere with the judicial process, risk affecting the fairness of the criminal trial, or furthermore prevent such a trial taking place. Well, again, what we respectfully submit to the court is that is, first of all, a statement by the Speaker. It's not a resolution of the House. Secondly, that it is subject, obviously, to what happens at the trial and to any submissions made to the judge at trial and any appellate court on the process. We do respectfully submit that's not an indication that privilege doesn't apply in this case, or that the exclusive jurisdiction doesn't apply. But it is merely covering all possibilities, must have a fair trial. In the end, it's a leave it to the courts statement in our respectful submission. We therefore respectfully submit against that background that Parliament has never stated, either by resolution of either House or by a decision of any committee, that MPs' claims under the ACA scheme fell within or without the scope of privilege or Parliament's exclusive jurisdiction. The express suggestions that they did not fall within privilege were made by two individuals connected with Parliament, but their opinions have not been ratified by Parliament and did not purport to express Parliament's views. And that, we would respectfully submit, applies equally to the Speaker's statement, which my Lord Phillips has drawn attention to. And Parliament has not purported to waive privilege or its exclusive jurisdiction in this respect, nor could it without first accepting that expenses claims fell within the ambit of privilege. So if it's waiver that one's looking for rather than the view of what the law is, there's been no waiver. And the final point we respectfully make is that there is, as it were, a constant theme in the Court of Appeal's reasoning, and certainly in the Crown's, that, as it were, you can't have dishonesty without having an appropriate punishment for dishonesty. And that, as it were, there can't be a lacuna. Actually, that type of question of whether every wrong must have a remedy was addressed back in the Bradlaugh decision, where Mr. Justice Stevens said it may well be that there has been an injustice to Mr. Bradlaugh, but it's simply not correct that every wrong has a remedy, the consequence of the exclusive jurisdiction of Parliament is that Parliament must itself adjudicate over conduct that might otherwise constitute an ordinary crime in this case. We respectfully submit that the exclusive jurisdiction of Parliament over certain limited internal matters and the concomitant ouster of the ordinary court's jurisdiction can be justified by the need to maintain a strong Parliament that polices itself in relation to such matters. The fact that MPs thereby attract differential treatment in that one respect is the necessary consequence of ensuring a limited area of parliamentary autonomy and the preservation of the separation of powers. And I've already made my submissions as to the countervailing advantages which are noted in Hallsbury, the swiftness of an internal procedure, of a internal contempt jurisdiction, the fact that it leads to coherence in the treatment of like conduct as between MPs, rather than some selectivity of some being dealt with internally for similar conduct as is then made the subject of criminal prosecutions. The fact that there can be political manipulation of charges, and the fact that in the end we respectfully submit, even if the the contempt code is an imperfect code, it has been recognised that where the contempt code applies and one's dealing with an internal matter, that is an exclusive jurisdiction. So, my Lord, those are our submissions on
Thank you very much.
Unless there's any other.
Yes. Lord Penn.
Lord and Lady, I have 5 preliminary points. First, I accept, as I did below, on behalf of the Crown, that of course these appellants are entitled to raise the issue of parliamentary privilege without being criticised for doing so. These are undoubtedly important questions of constitutional law. Second, my Lords and my Lady, we note that there is no dispute from the appellants that neither Article 9 nor the broader concept of parliamentary privilege prevent the prosecution of an MP for ordinary crime, whatever that means. The term used by Mr. Justice Stephen, than whom, of course, there was no greater authority on the principles of criminal law in the 19th century in Bradlaugh and Gossett, page 283, volume 1, tab 10. And Lord Coleridge agreed with Mr. Justice Stephen in Bradlaugh, pages 272 and 273. My friends each accepted that crimes falling within this category would include serious crimes committed by members of Parliament within the Palace of Westminster. They gave the examples which they accepted are indictable: assault on another member of Parliament, in the bar, in the office in the Palace of Westminster, or theft from the office of a colleague. Mr. Plemming also referred to the trial of the assassin of Spencer Perceval, the Prime Minister, in 1812 in the lobby of the House of Commons, murdered by a non-member of Parliament, an outsider. And my friend accepted that if the assassin had been a member of Parliament, privilege would not apply. The transcript is at volume 3, tab 25. It's of interest not merely because no question of privilege was raised at all at the trial, but Mr. Bellingham was in fact tried and convicted 2 days after the dastardly crime, and the Lord Chief Justice, who presided, Lord Mansfield, broke down in tears in directing the jury, pages 19 to 20. My friends also accept that an alleged offence by a Member of Parliament does not cease to be triable in the criminal courts, even if the conduct can be linked to parliamentary proceedings. Suppose the Member of Parliament is so aggrieved by what a colleague has said in a parliamentary debate that he confronts his colleague in the bar and he stabs him. My friend Mr. Fitzgerald accepted, in answer to my Lord Kerr, that this is not covered by privilege. Or to give another example, the MP is so anxious to get to Parliament in order to vote, in order to speak in a debate, that he drives dangerously around Parliament Square. Or he drives dangerously in the parliamentary car park and he runs over some unfortunate bystander and injures or kills them. It cannot avail the MP to say that his conduct was linked, perhaps closely linked, to parliamentary proceedings. That's the second point I wanted to make by way of introduction. The third point I wanted to make by way of introduction is that Article 9, and indeed parliamentary privilege generally, belongs to Parliament as a whole. It does not belong to, nor indeed is it designed to benefit individual members of Parliament. And the authority for that is Hamilton and Al-Fayed. It's volume 2 of the authorities. If the court would kindly look at volume 2, tab number 15, in the speech of Lord Brown Wilkinson, for the House, page 408, just under letter C, volume 2, tab 15, page 408, just under letter C, Lord Brown Wilkinson states, all parliamentary privilege exists for the better discharge of the function of Parliament as a whole, and belongs to Parliament as a whole. It doesn't exist for the benefit of individual members of Parliament. That's the third introductory point. The fourth introductory point is that in the present context, Parliament has undoubtedly been content to allow the criminal process to take its course in relation to allegations. Of course, they're only allegations of dishonest conduct by the appellant members of Parliament and others. There are other criminal proceedings pending, as your lordships and your ladyship well know. Now, this was a topic that was touched upon in argument earlier this morning in the light of questions from my Lord Roger to Mr. Fitzgerald. Can I make my position clear? We say that the Joint Committee was undoubtedly right when it said at paragraph 247 of its report, I don't invite the court to turn it up, but it's the beginning of paragraph 247, volume 5, tab 49. It said the dividing line between privileged and non-privileged activities of each house is not easy to define. They will undoubtedly, that's the quotation, and the court may see the wisdom of that assertion. But if it's right, and it is, and if there will undoubtedly be hard cases, and the court may take the view this is one of them, even though the determination of which side of the line a particular case falls is for the court. And it's of vital importance that this is a matter for determination by the court. I submit that in making its decision, the court will pay regard to the position adopted by Parliament. The court, of course, is not bound by what Parliament thinks, but we are, after all, dealing with the scope and application of a privilege which is vitally concerned with the relationship, the sensitive relationship, between the courts and Parliament. And I say that the court should be slow, with great respect, to recognise parliamentary privilege as excluding the jurisdiction of the courts in criminal matters when Parliament itself is not asserting, and it's not, that its privileges are being undermined, and when, perhaps more importantly, Parliament is not telling the world, and not telling the court, that privilege is needed to enable it, in this context, to perform its functions as a legislative and deliberative assembly. I use that phrase because that's the phrase that the Joint Committee used, and I'm coming back to that. And I say that Parliament has indicated repeatedly by its conduct that it is not troubled by these criminal proceedings. One sees this in a number of places. Reference has already been made this morning by, I think, my Lord the Deputy President, to the assertion by Mr. Justice Saunders at paragraph 21 of his judgment. If your Lordships and Ladyship have the appendix, it's at page 39, it's paragraph 21, where Mr. Justice Saunders says in the third line of paragraph 21 on page 39, it is nevertheless a fact that neither House has sought to assert that these proceedings come within the jurisdiction of Parliament. This is of particular significance, as the privilege, if it exists, belongs to Parliament, not the individual members. Parliament has, to the best of his Lordship's knowledge, cooperated with both the police inquiry and the court in these proceedings. And then he goes on to deal with other matters. The Court of Appeal similarly addressed this matter at page 20 of the appendix. It's at paragraph 70, where they refer at paragraph 70 to what they describe as the realities. And in my respectful submission, these are the realities. Parliament is rightly jealous of any actual or potential infringement of its privileges. If there were parliamentary concern about a possible breach of privilege arising from a prosecution based on fraudulent claims for expenses by members, we have no doubt that formal steps would have been taken by the Speaker and Lord Speaker to raise the question with the court. Parliament has simply not objected, indeed it has cooperated with the criminal investigations in these three cases and other cases. The court will be well aware that there have been many cases, indeed, where the Speaker and the authorities of the House of Commons have intervened and been separately represented in legal proceedings in the courts in cases where questions of privilege arise. For example, in Hamilton and Al-Fayed, Volume 2, Tab 15. In Buckingham, the judgment of Lord Bingham for the Privy Council that the court saw yesterday, the New Zealand case, Volume 1, Tab 11. And there are at least two other modern examples in the documents. The Bradley case, Volume 2, Tab 21, Federation of Tour Operators, Volume 2, Tab 23. In each of these cases, the authorities of the House of Commons, the Speaker, are represented by counsel to present a view. In the present case, I can tell the court that the Speaker of the House of Commons instructed counsel, who has a watching brief, who did not seek to intervene in the Crown Court but was present, similarly in the Court of Appeal, and I understand that the Speaker is similarly represented in this court. Of course, it goes much further than that, because this court has a number of clear indications in the documents that Parliament has repeatedly and consistently taken the view that it is content to allow criminal proceedings in this context to go ahead. My friend Mr. Fitzgerald referred to them, so I can deal with it briefly. First, there was the statement by the Parliamentary Commissioner for Standards to the House of Commons Committee on Standards and Privileges. That was Volume 5, Tab 50. His statement was at paragraph 46 of the appendix that privilege did not apply, and the committee did not dissent from that. Then there is the tripartite agreement, which is dealing with general matters, as Mr. Fitzgerald rightly said. It's not dealing specifically with prosecutions in relation to expenses. The tripartite agreement is Volume 5, Tab 52. But the relevance of the tripartite agreement is that the principle it contains has been applied repeatedly in the context of allegations about expenses claims in both the House of Commons and the House of Lords. And in the many cases, which include these three, where the police have been investigating and decisions have been taken about whether to prosecute, the parliamentary authorities have delayed their procedures to allow the criminal process to take its course. That's what's happened. And the latest example of that, which was mentioned by my friend Mr. Fitzgerald a few moments ago, is the case of Mr. Dennis McShane. If your lordships and your ladyship have the short additional document that should be on the side, it's headed at the top, House of Commons, Mr. Dennis McShane, Standards and Privileges Committee. The court will see at the bottom of the page the report from the House of Commons Standards and Privileges Committee. And what they say is that at their meeting last week on the 12th of October, they agreed that the Parliamentary Commissioner for Standards should report to the Metropolitan Police Service the conduct of Mr. McShane in accordance with the tripartite agreement. This is the first page, Lord, at the bottom. In accordance with the tripartite agreement, the Parliamentary Commissioner for Standards and the Police, the Commissioner's inquiry into a complaint against Mr. McShane will be suspended until the question of possible criminal proceedings has been resolved. And over the page, the court has some detail as to what these allegations actually are. It is plainly inconsistent with all of that to suggest that Parliament is objecting in any way to the criminal process being pursued in relation to this general topic. Similarly, the court
I notice in the last page of this handout that he's thought to be the first MP to be referred to the police by the parliamentary
Well, that's
authorities.
simply wrong.
I'm sorry?
That's simply wrong. He's not the first MP who has been considered. I see, yes, he may be the first who has
I mean, there have been
specifically
others considered, I quite see that.
he may be the first who has specifically been referred, but that in itself is of great interest, that in the earlier cases, at the very lowest, the parliamentary authorities have proceeded on the basis that their inquiries will be delayed while the police authorities decide whether or not, with the CPS, there are to be prosecutions. And one sees that in the case of the three peers, in respect of whom yesterday the House of Lords Privileges and Conduct Committee issued reports. The court may have seen last night that the House of Lords Privileges Committee issued reports into the conduct, I should say the alleged conduct, of three peers.
I think it's to be debated today, isn't it?
It's being debated on Thursday.
On Thursday,
On Thursday. And if the court has a copy of this document, it's a document, the House of Lords, the conduct of Baroness Udin. There are three peers, but I've photocopied for the court the Baroness Udin report. They are similar in their terms. What the court has, there are two documents. The first one is 8 pages. The second one is 19 pages. The first one is the report of the Privileges and Conduct Committee itself. The second document is the appendix to that report, which is the report from the subcommittee. And I would like to invite the court's attention to the second document. It's page 2 of 19, which shows how the House of Lords, like the House of Commons, are proceeding in this context. If the court has page 2 of 19, paragraph 6 is headed Procedure in this Investigation. And we're told that in May 2009, the Lord President, Baroness Royal, announced that the Clerk of the Parliament would carry out an initial investigation into the allegations against Lady Udin. She met and corresponded with the Clerk of Parliament in relation to the investigation. The police had meanwhile decided to investigate whether she committed an offence under the Theft Act or the Fraud Act. The Clerk of the Parliament suspended his investigation into Lady Udin until the criminal process had concluded. In March, a joint CPS Metropolitan Police Service panel decided not to prosecute, and the Clerk of the Parliament resumed his own investigation, and he asked the subcommittee to investigate. So what happens is that if there is any criminal investigation, the parliamentary authorities stop, they let the criminal process take its course, and if the criminal process leads to no prosecution, then, but only then, does the parliamentary procedure start. And this is an application of the tripart agreement. It shows very clearly the attitude of the parliamentary authorities, as does the Legg report. The court saw yesterday the Legg report. I won't go back to it unless I'm asked to. Volume 5, tab 60. It is stated very clearly at page 5, paragraph 8, page 14, paragraph 43, that Sir Thomas Legg was given by the parliamentary authorities no jurisdiction. His terms of reference excluded matters which were the subject of criminal inquiries. Again, Parliament recognising that the criminal process must be allowed to take its course in this specific context of allegations about parliamentary expenses. So I say...
We aren't to be in the least troubled by the sort of curious discordance between the way that, for example, Baroness Udin's dealt with and whoever the...
Lord Hanningfield.
Hanningfield or wherever he's from, yeah.
troubled by it. No, my lord, for this reason. In both cases, the parliamentary authorities have allowed the criminal process to take its course. A decision was taken in the case of Baroness Udin that no criminal prosecution should be brought on the merits of the case, by contrast with the case of Lord Hanningfield.
I know, but then you see what happens to Baroness Udin, and apparently the House of Lords authorities, the relevant committees, find her to have acted in bad faith, and therefore, on the face of it, they found she's guilty of what would have been a Section 17 offence.
Well, nothing that the court does, of course, is going to limit the powers of the parliamentary authorities to make a decision on the facts of particular cases. But that doesn't, in my submission, affect the issue of principle with which we are concerned, which is whether or not, by reason of parliamentary privilege, the courts enjoy jurisdiction over these matters. And the point I'm making, and I've made it, so I shall move on, is that Parliament itself is simply not troubled by the courts enjoying jurisdiction in this general area. And if that is so, I say that is highly material to the court's determination of the scope and the application of parliamentary privilege and whether it should recognise a privilege in this context.
Is there any indication of the extent to which Parliament has actually been assisting the police in their investigations? The point I made, it's very hard to conceive of how they could, in practice, conduct investigations without that assistance.
There's no material before the court, but there's never been any challenge to the finding that was made by Mr. Justice Saunders, who is, of course, after all, the trial judge. He's been dealing with all the interlocutory applications. He will be, if the court allows the criminal trials to proceed, he will be the judge who hears each of these cases one after the other. Parliament has been providing the CPS and, as Mr. Fitzgerald indicated, the defence with what they require. There is a dispute, limited dispute in the Hanningfield case, which is not before this court, as to the scope of the cooperation, and Mr. Justice Saunders may need to deal with that. But that is the finding by Mr. Justice Saunders. There has been full cooperation, and I respectfully agree with my Lord the President that it is quite impossible to see how a prosecution could be brought in this context without cooperation from the parliamentary authorities.
Lord Pang, I mean, flipping, which, you know, as members of the public we all know about, there are no proceedings in respect of those cases, are there?
In relation to the residence of the individual, I don't think there are, my Lord, no. Unless Lord Taylor, I'm not sure whether... Would your Lordship give me a...
Baroness Scotland. Baroness Scotland.
It's not an allegation. It's not an allegation in any of the cases, no.
No. I mean, one just wonders. I can't help sort of reflecting, you know, that because an awful lot of people that did that, and an awful lot of people said, well, that was the accepted practice. That was, in effect, the deal. That was part of the recognised basis on which you claim expenses. Now, I mean, if the prosecution had in fact decided, as on the face of it, one can very well think the CPS had decided that on the face of it they might well have done, you know, good gracious me, you know, why don't we prosecute here? One wonders whether the House of Commons authorities would have, you know, seen it quite in the same way.
Well, they may or may not, Lord. One is speculating with great respect. In relation to these cases, there is simply no evidence to suggest that Parliament is at all concerned that its privileges are being undermined. On the contrary, it has cooperated. There are repeated statements that it is content for the police to investigate and for prosecutions to be brought. And the final example of that was mentioned by my Lord, the President, the Speaker's statement, to which my Lord drew.
How do these cases, Lord Pat, how do they start? And how did these three just start? Who started them?
Well, they started by information coming to the attention of the police.
Well, of course, I know that. Who supplied
Well,
this
I don't know
information?
is the answer.
It's very interesting, isn't
Yes,
it?
it is interesting.
Who supplied it?
Daily Telegraph.
Is it in the newspapers?
Daily Telegraph.
Well, there were newspapers. Yes, thank you, my Lord. There were newspaper
But they just
reports.
the police just chose these ones.
The police took the view. Well, they investigated a number of cases,
Yeah.
and they decided that in particular
These
cases,
three or whatever it was.
their view was that there was sufficient evidence, and it was in the public interest for prosecutions to be brought. They considered a large number of other cases where they decided that it was not appropriate. And since then, as the court knows, there have been other cases started. There's another former member of Parliament who is facing criminal proceedings. There is another peer, Lord Taylor of Warwick, who is facing criminal proceedings in relation to these matters. That's all by way of background. I say it's important matters that I invite the court to take into account when dealing with I accept difficult questions, and I assert sensitive questions about the relationship, which is what this case is all about, the relationship between the courts and Parliament.
Even though it is a difficult question, you say it may be surprising that the Speaker hasn't come along to explain his position and so on. Nonetheless, we take into account the fact that the parliamentary authorities, you say, seem relaxed about it.
Yeah, can I make it clear? I'm certainly not criticising the Speaker.
No, I'm not suggesting for a moment.
I assert that the Speaker's position is entirely consistent with all that has happened, and it is with the greatest of respect simply unrealistic for my friend to suggest that Parliament, through the Speaker, through the committees of each House, has taken no position. It has accepted, without quarrelling, and it has cooperated, Parliament, with these criminal investigations and with the prosecution. That's the finding by Mr. Justice Saunders, and it's entirely consistent with all that has gone before, from the statement by the Parliamentary Commission in 2003, the advice from the clerk that has been publicised, all those matters. So can I then...
I'm sorry.
No, please.
Leave it at this, but I mean, just assume there was a prosecution for flipping.
Yeah.
And the defence was, well, now this was accepted. This was the culture of the place, and this was discussed, and the people, officials in the fees office, all, etc., etc., etc. Now, would that all have to be ventilated in the trial?
If the question was one of dishonesty, then I can see that in some circumstances, the attitude taken by particular people would be relevant to the question of whether the ordinary person would regard the conduct of the Member of Parliament in question as dishonest. The Crown has to prove dishonesty. And I also recognise that if this court allows these criminal trials to continue, because we're dealing with an issue of principle, then Mr. Justice Saunders has a continuing responsibility to ensure that parliamentary privilege is protected. And plainly, one can imagine, in theory, circumstances where the defence need a particular document that Parliament is reluctant to provide. But these are all theoretical problems. They are problems that, if they arise, Mr. Justice Saunders will need to address. And
But if that were to happen, I mean, does that mean that at that point it's apparent that the conduct is covered by parliamentary privilege?
Well, it's very far along the line, because Mr. Justice Saunders has to determine first whether this issue is relevant in the criminal proceedings. He then has to determine whether there is a dispute of fact, or whether the Crown are prepared to make a concession as to fact. If not, Parliament may well be prepared to provide the information. If not, then Mr. Justice Saunders has to determine whether it would be unfair for the case to continue in the absence of whatever this information is. These are all questions that theoretically could arise, but they're very different from the question that we're considering today, in my submission.
But it's only in a case of obvious, blatant dishonesty that you say you don't run into the problem.
No, I don't submit that. I say these are cases. With great respect, I say, and I don't want to get into the facts of these cases, but I say these problems simply do not arise on the Crown's case in relation to these appellants. I can well understand that there might be other criminal prosecutions where one does run into what is undoubtedly the core privilege of Parliament. My Lord the President asked a question about the Police and Criminal Evidence Act, to which my answer would be that the courts cannot force the parliamentary authorities to do anything relating to their own building and the documents that they have. I mean, if there were a real dispute, then Parliament will take its position. But that is a theoretical problem that one hopes would never occur. And if it did occur, solutions would be found. But I don't accept that those theoretical problems are any answer to the issue, or throw any light on the issue that arises in the present case, any more than questions that may arise in other contexts of immunity prevent cases from being heard. May I then turn, my lords, my lady, to what I say are the relevant principles for identifying the scope of parliamentary privilege? And can I deal first with my friend Mr. Fleming's points, and then seek to deal with Mr. Fitzgerald's submissions, although almost all of the points are relevant under both heads. In relation to principles, we say that the starting point in relation to Article 9, and indeed in relation to the broader concept of parliamentary privilege, is that there is high judicial authority, that privilege should be confined to core or essential functions. And this is the Buchanan case. If I could ask the court please to go back to Bingham's judgment for the board in Buchanan, Volume 1, at tab 11, a striking case where the libel claim is brought against the Member of Parliament in New Zealand because he has said outside the House that what he said inside the House is true, or rather he says he does not resile from his earlier statement inside the House. And the plaintiff sues the Member of Parliament and he pleads the words of the original statement inside the House. And the question is whether privilege applies. And the board says no, privilege does not apply. This is one of those cases, see page 117A, where the counsel appears, Crown Counsel from New Zealand, appears for the intervener, and the court sees that the intervener at 116F is the Speaker of the House of Representatives in New Zealand. And I take this briefly because Mr. Fleming took the court to it yesterday. It's at page 123. Lord Bingham for the board at letter G refers to the Joint Committee's executive summary. This legal immunity is comprehensive and absolute. Article 9 should therefore be confined to activities justifying such a high degree of protection, its boundaries should be clear. And he then cites with approval the observations which the court saw yesterday from Viscount Radcliffe in De Livera, the test at letter H, his real or essential function as a member. Mr. Fleming pointed out, of course accurately, that neither this case nor De Livera was concerned with claims for expenses, but the cases are setting out principles, and it may be helpful just to look at the Joint Committee's analysis which led to the conclusion in the executive summary which Lord Bingham refers to. The Joint Committee's report is volume 5 at tab 49. And the passage that Lord Bingham cited from the executive summary in volume 5 tab 49 is in the middle of page 1, numbering at the top of the page. After the Roman numerals, we come to the report proper, and page 1 is the executive summary, and in the 5th paragraph down, this legal immunity is comprehensive and absolute. Article 9 should be confined to activities justifying such a high degree of protection. Its boundaries should be clear. We then come to the substance of the report after the executive summary, and as was pointed out yesterday, this committee was considering not merely Article 9, see paragraph 12 on page 10, it was also considering the wider concept of privilege, paragraph 13. And the committee may be assisted by looking at page 34, which is paragraph 110, where the committee say there is another consideration. This is page 34, paragraph 110. There is another consideration. Article 9 provides an altogether exceptional degree of protection, as discussed above. In principle, this exceptional protection should remain confined to the core activities of Parliament, unless a pressing need is shown for an extension. It's true that that passage appears in the part of the report dealing with members' correspondence, but it is stating in my submission a general view of the committee, and if there were any doubt about that, it so appears if one turns, please, to page 64, at paragraph 241, where they are dealing with the right of each house to administer its internal affairs within its precincts, and they refer to internal affairs being loose, potentially extremely wide. They say this would embrace at one edge of the spectrum the arrangement of parliamentary business, at the other extreme the provision of basic supplies and services. The latter would be going too far. And then they say this: here as elsewhere, the purpose of parliamentary privilege is to ensure that Parliament can discharge its functions as a legislative and deliberative assembly without let or hindrance. This heading of privilege best serves Parliament if not carried to extreme lengths. And that's the principle that they identify and which we commend to the court.
And supposing that an MP were disgruntled with the level of expenses which he was permitted to claim, could he raise that in courts? Could he ask for judicial review of the matter?
He could not, my lord, for this reason. if he were to bring a judicial review, it would be a challenge to a resolution, a purported challenge to a resolution of the House of Commons itself, which has approved, as my friends made clear, the terms of the expenses scheme. And I accept, indeed I assert, that parliamentary privilege, great respect, gives the courts no jurisdiction over decisions taken by Parliament, and that would be a good example, or I accept over decisions taken by the Speaker on behalf of Parliament, my Lord Kerr's case of McGuinness. What I say is very different about this case is that the court is not being invited to consider, to impugn a decision by Parliament or by the Speaker. It is considering a case about the conduct of a particular member of Parliament.
I don't understand why this would be a challenge to the Speaker or Parliament at all.
In the present case?
No, in my Lord's example, the MP says, look, these are the rules, but I haven't been allowed my allowances in accordance with the rules.
I see. I'm sorry. I thought your Lordship was...
I was about to ask. There's one in print that
I misunderstood your Lordship.
Your answer answers the principle, but
Yes.
it's about the application.
Yes.
Suppose in the application in an individual case.
I see. Well, if the complaint were that the committee, the fees office had given the wrong answer in my individual case, the court would refuse to entertain the application on the basis that the Member of Parliament has a remedy. He can take his complaint to the committee. The committee of Parliament has full jurisdiction to consider the case against him, and that would be his alternative remedy. The court wouldn't entertain an application in those circumstances.
So what if he says he's already done that and got nowhere? He's already tried to follow the...
Well, then he will have had a decision by the committee, and the attempt to bring a judicial review would be a challenge to the decision of the committee of the House or of Parliament itself. That would be his problem in the circumstance that my Lord...
Is that a core function then?
It would be a challenge to a decision of a committee of the House of Commons.
Core function, in relation to the core function of Parliament, which is what your test is.
Well, it would, yes, if a committee of the House of Commons has made a determination, a formal determination, then it cannot be open, I accept, to the courts to entertain a judicial review of such a committee decision. But there is a real distinction in my submission between the court being invited to entertain a judicial review application which directly challenges the decision of the committee of the House, or indeed of the House itself, and on the other side of the line, a legal proceeding which involves the prosecution of a Member of Parliament for his alleged conduct in relation to the contents of the form that he submitted. Now, there are obviously going to be very difficult cases, but your Lordships and your Ladyship are deciding on which side of the line this particular case falls, and that is a real distinction in my submission.
It's not...
Sorry.
Is it just the nature of the function we should be focusing on? Might it not be a combination of that and the level at which the function is being taken?
Yes.
I mean, if a function is something which can actually be delegated down, so to a point where it is purely incident administrative, isn't that relevant?
I would respectfully accept that, my Lord, which is why I undoubtedly accept that judicial review cannot lie if the Member of Parliament's complaint is about a resolution of the House itself. And I also accept, going one level down, there cannot be judicial review of a decision that's taken by the Speaker, the McGuinness case, in relation to the allocation of the facilities of the House. But I do respectfully accept your Lordship's point that the lower down the level one goes, the more difficult it is necessarily for it to be asserted that this is a matter which concerns the functions of Parliament as a deliberative and legislative assembly. And the 2 points, if I may respectfully so submit, are linked, because it is the very fact that the function is at the lowest of levels, that is, the official is dealing with it, that supports the argument that it is not, as a matter of substance, a matter which relates to the deliberative functions of a legislative assembly.
What about the terms of the form itself? We see this at page 115
Yes.
at the back of the appendix. And my point really is that whoever signs this form is asserting that he's doing so, he's incurred these costs and so on for the purpose of performing his duties as a member of Parliament. And that's common to everybody.
But everybody
who submits this form. And he's in effect saying, I need this.
Absolutely.
In order to perform my core function as a member.
I accept, and we've accepted in our written submissions, that there are undoubtedly links between the parliamentary expenses scheme and the claim that is made and the performance of the functions of the MP. Parliament establishes the expenses scheme because it believes that members of Parliament need to be paid expenses in order the better to perform their parliamentary functions. But the question remains whether or not the act which is indicted, the act of completing the form, is itself an act which is so closely related to the performance of the core functions of the Member of Parliament that it should benefit from parliamentary privilege. And the test suggested by the joint committee is that one needs to be very careful here. Paragraph 247, if I could invite the Court's attention to page 66 of the joint committee's report. We're in volume 5, tab 49. Paragraph 247, they say, and I've referred to this already this morning, the dividing line between privileged and non-privileged activities of each house is not easy to define. The nearest approach to a definition is that the areas in which the courts ought not to intervene extend beyond proceedings in Parliament, but the privileged areas must be so closely and directly connected with proceedings in Parliament that intervention by the courts would be inconsistent with Parliament's sovereignty as a legislative and deliberative assembly. That's the test that the joint committee adopt. Now,
unless it were an actual decision of the House.
Yes.
Or of a committee.
Or certainly of the Speaker, or the lower down.
If it were a decision of the House, however frivolous,
yes,
it would attract.
I cannot envisage any circumstances in which the court would entertain a judicial review of a decision made by Parliament itself.
However frivolous.
Whatever its content, the court would simply not entertain the contention that this is a frivolous decision by Parliament.
And the same would be true of a committee, would it?
I have difficulty in envisaging circumstances in which a decision of a committee of the House.
So when you come to delegates of the
delegated
matter, then you apply this test.
In my submission. Now, I say that this makes good sense. This narrow approach, a confining approach to parliamentary privilege, because, my lords and ladies, when the court decides on the scope of parliamentary privilege, there are a number of competing relevant public interests. There is the vital interest, of course, in ensuring, to use the joint committee's language, that the courts never intervene where that would be inconsistent with Parliament's sovereignty as a legislative and deliberative assembly. It's paramount. And of course, the courts must not do that. But if we're at the edges, and at best from the appellant's point of view, we are at the edges in this case, the court will also want to consider other important public interests. There is, for example, the vital public interest of ensuring that unless immunity privilege is truly necessary to enable Parliament to perform its functions as a legislative and deliberative assembly, a person should not, by reason of their status as a Member of Parliament, enjoy a special protection against what would otherwise be their prosecution. And the general principle of the law, which has relevance here if we are at the margins, is the principle to which Lord Bingham drew attention, again for the Judicial Committee, not in the context of immunity, but as a general statement, the principle of equality. And the principle is in the Sharma case. It's volume 3. Could I invite the court, please, to go to volume 3 of the authorities at tab 31. Sharma and Brown Antoine. It's a case about, it's a judicial review of a decision of the authorities in Trinidad and Tobago to prosecute in a sensitive context. And at page 786, at the bottom of that page of tab 31, volume 3, Lord Bingham for the board sets out at the bottom of page 786 at H what he describes as governing principles, and the first of them is the relevant one. The rule of law requires that, subject to any immunity or exemption provided by law, the criminal law of the land should apply to all alike. A person is not to be singled out for adverse treatment because he or she holds a high and dignified office of state, but nor can the holding of such an office excuse conduct which would lead to the prosecution of one not holding such an office. The maintenance of public confidence in the administration of justice requires that it be, and it be seen to be, even-handed. Now, if this is a case truly where prosecution will damage the performance by Parliament of its functions, then of course immunity must be recognised, privilege must be recognised. But if there's any doubt, then I respectfully submit the court should be very cautious about recognising too extensive a privilege because of the competing principle of equality. And similarly, there are other important public interests which we invite the court to have regard to in deciding the scope of privilege. Another important public interest is to ensure the true separation of powers. And under the separation of powers, it is for the criminal courts to consider allegations that persons, including members of Parliament, have committed criminal offences, to ensure that any such allegations are fairly tried by a proper procedure, an independent procedure, before impartial judges. And of course, if privilege truly applies, then it will be left to Parliament to consider these matters, but it is highly desirable that the separation of powers involves courts of law determining serious allegations of wrongdoing. And no doubt Parliament has these points well in mind in not asserting privilege in the circumstances of this case. These points about separation of powers and equality were made in the Greenaway case, which the court was referred to yesterday, the alleged bribery case, or before Mr. Justice Buckley. I won't take time on it, but it's volume 2, tab 26.
I don't want to be pedantic, Lord Bennett, but I'm about to be. Did the majority in Sharma and Brown Antoine expressly agree with the minority opinion on this? I'm not suggesting that we might have done, but I don't remember that we did.
Your ladyship will know far better than me whether the...
I have an intimate recollection of that case. As no doubt that my Lord knows.
well, paragraph 30, your ladyship and the other members of the majority, including my Lord Mance, said that you had the benefit of reading the opinion prepared by Lord Bingham and Lord Walker. We shall, in its light, confine ourselves to what we perceive as the main areas where there may be a difference of view or emphasis. And I, for my part, did not understand.
And we then went on to say that judicial review of a decision to prosecute is an exceptional remedy of last resort for all the reasons that Lord Bingham
precisely so.
points out in paragraph 14.
Precisely. So I didn't understand there to be any dispute about the core
I wasn't suggesting that there was.
I'm very grateful
to be acknowledged.
No, I'm
that
grateful.
Lord Bingham was not speaking for the committee.
Your ladyship is certainly not pedantic. It's quite right to point out this was a minority opinion, but was speaking for the board in this respect because of the concurrence of the majority on this particular point. And there's a further public policy, it's not merely equality, separation of powers, there's a further public policy of relevance here if we are in the realm of the margins of privilege. And it is a sensitive one, but it's one I mention nevertheless. It is that for the courts, with great respect, to recognise too broad a scope for parliamentary privilege may damage the reputation of Parliament. Mr. Fleming referred to the colourful statements, and they are colourful statements, to this effect in the judgment of Lord Brougham, the Lord Chancellor, in the Wellesley case. I won't go back to it, it's volume 3, tab 36. And it's certainly no part of my submissions for the Crown. I made this point below and I repeat it. I'm certainly not suggesting that the appellants in the present case are making wild and extravagant claims to privilege, which was the criticism in Wellesley. What I do submit is that it is one of the functions of this court when it is defining and applying the concept of parliamentary privilege to have regard to the need to ensure that privilege is confined to what is truly necessary to enable Parliament to perform its functions, because any broader approach would undoubtedly risk damage to the reputation of Parliament. So my second point is that there are strong public interest reasons for confining privilege to core activities outside the plain and obvious cases.
That's what the public wouldn't like you to point, is it?
Well, it's more than that. With great respect, I mean, one is dealing here with a most sensitive issue of the relationship between Parliament and the courts. And the courts are the ones who decide. The courts, I say, should have regard to the views adopted by Parliament, and as Wellesley makes clear, it is inevitable that the broader the scope of privilege, the greater the damage that may be caused to the reputation of Parliament. That is a factor which is relevant. Now, there's a third important matter which is relevant to Article 9, and it's what is the purpose of Article 9? And the purpose of Article 9 was considered by Lord Brown-Wilkinson for the Appellate Committee in Pepper and Hart. It's volume 2 of the authorities. If I could invite the Court's attention to volume 2, tab 19. And Lord Brown-Wilkinson, in tab 19 of volume 2, deals with this matter of the purpose of Article 9 at page 638. And at page 638, letter C, Lord Brown-Wilkinson, speaking for the appellate committee, identifies that the submission was that the use of Hansard for the purpose of construing an act would constitute a questioning of freedom of speech or debate. The process, it said, would involve an investigation of what the minister meant by the words he used, would inhibit the minister. This, it was submitted, constituted questioning. And then he says, Article 9 is a provision of the highest constitutional importance, and it should not be narrowly construed. It ensures the ability of democratically elected MPs to discuss what they will, freedom of debate, to say what they will, freedom of speech. But even given a generous approach, His Lordship found it impossible to attach the breadth of meaning which the attorney urges. And then at G, and this touches on the point raised yesterday by my Lord Mance as to what the original intention was. In my judgment, says Lord Brown-Wilkinson, the plain meaning of Article 9, viewed against the historical background in which it was enacted, was to ensure that MPs were not subjected to any penalty, civil or criminal, for what they said, and were able, contrary to the previous assertions of the Stuart monarchy, to discuss what they, opposed to the monarch, chose to have discussed. Relaxation of the rule, that's the Hansard rule, will not involve the courts in criticising what is said in Parliament. So this is all about freedom of speech in Parliament, the role of Parliament as a legislative and deliberative assembly. And we are...
For completeness, I might follow Lady Hale's point on Sharma. The Lord Chancellor, of course, dissented, but you'll find at page 614, letter E, that he agrees with what Lord Brown-Wilkinson says on that.
Well, I'm very grateful.
Lord Brown-Wilkinson wasn't speaking for the entire committee.
No. that is, it was a committee, if I remember rightly, of 7. And Lord Mackay, Lord Chancellor, dissented. Yes.
So, but agreement on this point.
Yes, indeed. Indeed. So, Article 9 is a provision, a most important provision, of course, about freedom of speech. And I say we are a very long way away from concerns of the sort that Article 9 is designed to address and has been understood to have addressed, not merely in the 18th century, 17th century, but ever since in the circumstances of this case. So may I then turn to the application of these principles in the specific circumstances of this case. And I do submit, I've made the point already, that the submission of the claim form, which is what is impugned, the contents of the claim form of what is impugned, the act in issue in the criminal proceedings, is certainly not a decision of Parliament. It's certainly not a decision of the Speaker or of any committee. It's not the performance by the Member of Parliament, in my submission, of any core or essential parliamentary function, having regard, as I invite the Court to do, to the factors that I have drawn attention to, supported by Buchanan, supported by the Joint Committee, as supported by the public policy arguments, as to the reasons for confining privilege and having regard to the purpose of Article 9.
How would you put it positively? I mean, you've said what it isn't. What is it, if you may put it in a positive form, what does it amount to?
It amounts to an administrative act. Your Lordship is asking me about the claim form.
Yes.
Yeah, it amounts to an administrative act which is designed, and very properly so, designed to claim a financial benefit for the individual Member of Parliament. That's what it amounts to.
Do we have the Green Book? I don't think we do.
Appendix.
Yeah.
We have extracts from it in the
We've
appendix.
got 3 different versions of extracts from it.
82 onwards.
Appendix
82.
Does the claim form precisely echo the word? Yes, we got it. Sorry, I've got it at 94.
Yeah.
Does it precisely echo the wording of the Green Book?
In other words, exclusively and necessary to enable me to stay overnight away from my own...
Yes, page 115 is the declaration.
Page 86.
Yes. Does that precisely echo the Green Book?
Lord, page 86.
Yes, the
311.
It's
3.1.
yeah. Yes, page 86, paragraph 3.11.
Yes, and
Indeed so.
and 3.82. So there could be questions which would arise as to the interpretation of that, and I suppose as to its factual significance. What is involved in performing duties as a member of Parliament? What even was the person there on the day?
Factual issues may well arise, yes, and of course the Crown Court will have to be sensitive, as in all cases where there is an overlap between Parliament and the courts, not to trespass on the true privileges of Parliament. But the same problems could arise in a Bellingham case. It could arise in the case which my friends accept is indictable, of the Member of Parliament who punches the colleague in the bar of the House of Commons because of what has been said in the proceedings in the House.
So supposing a question arose as to what was meant by some obscure passage in the additional cost allowance in the Green Book, that's a provision which Parliament has enacted. I think it's accepted that the enactment of the scheme is privileged. Would that create a problem? Could it create a problem in the course of criminal proceedings?
No, the courts regularly, of course, determine what Parliament meant by what it has said, whether it's in legislation, it's in subordinate legislation, it's in resolutions. Indeed, the whole point of Pepper and Hart was to allow the courts to attempt to, the better, to implement what Parliament has determined. And of course, the function of the court in the type of case that your Lordship is putting to me, and I don't accept these points arise at all in these three cases, but assuming they do, the function of the court would be the better to understand and give effect to what Parliament has decided, not to question it, not to frustrate it.
What about the phrase, your parliamentary duties, or my duties as a member of Parliament? You see that at page 114, 115. If there was a dispute about what he was actually up to during the period in question, as to whether or not that fell within that phrase, would that be for the court to determine, or would it be for Parliament to determine?
I don't accept that there would be any breach of parliamentary privilege if there were a dispute in the court attempting to identify the true position in relation to that, what the Member of Parliament may have been doing at a particular time. I mean, obviously, in performing that function, the court would be very sensitive indeed not to trespass upon matters of true parliamentary privilege. But the exercise in itself, I do not accept, is an exercise by the court that breaches parliamentary privilege.
So can an MP sue for the House of Commons Authority, whatever it's called, for payment of his expenses?
This takes us back to the question I think your Lordship was putting to me before.
I'm just asking, can he sue for them?
No, I wouldn't accept that he can, because he is entitled, if the Fees Office do not pay him the sum which he regards as properly due under the scheme that has been created by Parliament, he has an entitlement to say to the committee, I wish you to overrule the
no
fees.
legally enforceable debt.
Would it be an enforceable debt?
Yes.
I have some difficulty in seeing how the individual MP could invite the court to exercise jurisdiction in relation to the failure of the parliamentary authorities, Parliament itself, to pay what the MP said is owed. I would respectfully submit that that cannot be a matter for the jurisdiction of
How about a contractor who's carried out some building work? With whom is his contract?
Your Lordship raises a matter that was discussed in the lower courts, that one may have cases where the authorities of the House of Commons, a committee, enter into a most detailed scheme, comparable to the details of the scheme for expenses, with building contractors, which specify the work that needs to be done, it specifies the methods of payment in relation to these matters. And the submission, certainly I made in the Crown Court, was that if the contractor acts in a dishonest manner, then the contractor would be liable to prosecution. Now, if the contractor complains that the authorities of the House of Commons have not paid what is due, then again, I would respectfully submit the court would be very slow indeed to recognise that it has power over the authorities of the House of Commons, assuming that the House of Commons is refusing to pay. I mean, the reality of this case is that the case would not reach court unless the authorities of the House of Commons were refusing to pay for a reason. I mean, they're not going to refuse to pay simply because they decide they're not going to comply with their contractual obligations. But if they refuse to pay, for example, because they think the work is shoddy, then I would be very slow to concede that the court would have jurisdiction over the authorities of the House of Commons for their refusal to meet what is said to be their obligations. I mean, one can see that there would be difficulties about a clash between the authorities of Parliament and the courts.
Because it's within their exclusive cognizance, is that it?
Because
they're not a body susceptible to suit in...
I'm assuming in the type of case that Your Lordship puts to me that the contractor, the aggrieved contractor, will have said to the committee which is supervising this issue, I am not being paid, and the committee will have taken a decision. And if the committee has taken a decision, it is a committee of Parliament, then I can see a strong argument that privilege would apply and the court would not entertain a challenge to that decision, which would be a decision we're not paying because you haven't done the work properly.
So you can't enter into a contract, a building contract with Parliament if you're a builder, which would create legal relations between you.
Well, you can enter into a contract which you would hope and expect would create a legal relationship. The problem is one of jurisdiction, whether you can go to the court and compel Parliament to pay up if the authorities of Parliament decide that they're not going to pay. I'm conscious in answering this question. I, of course, don't object to the question, but I'm conscious that I haven't studied Erskine May on whether there's any authority on this. My friend Mr. Fleming tells me there is, and no doubt he will refer to it in reply. But as a matter of principle, I can see the difficulties in the court forcing Parliament to pay up if Parliament decides it's not going to do so. I see the force of that. So I say, getting back to the claim for expenses by the individual member of Parliament, that what it is positively, to answer the Deputy President's question to me, is that it's an act, that's the submission of the claim form, that's primarily concerned with claiming a benefit, financial benefit for the MP himself. It's well outside the scope of the free speech justification for Article 9. I say it's well outside the core functions of the MP, the core functions of the MP being to speak in Parliament, to participate in the work of committees. It's a function that is addressed by Parliament itself at the lowest level of the official in the Fees Office, precisely because, as I said in answer to my Lord Mance, it is purely an administrative matter, and Parliament itself has made it clear, I've made this point, that it does not regard these matters as properly covered by privilege. Now, we also submit that the appellants have to answer these difficult questions. If they are right, do they assert that privilege applies if the MP is in dispute with the Fees Office about the payment of expenses, and the Fees Office have refused to pay £100, which the MP regards as properly owing? And so the Member of Parliament goes to the Fees Office and he helps himself to the cash from the petty cash box, and he pushes aside the Member of Staff assaulting him or her in the process. Now, I assume that the appellant's answer would be no, this is not covered by privilege, this is a matter that is indictable. But if stealing £100 from the Fees Office may be the subject of a prosecution, it is a very fine distinction to say that dishonestly, which is the allegation, dishonestly submitting a claim form for the £100 may not be the subject of a prosecution. Speech cannot make the difference in this context. My friend Mr. Fitzgerald made a submission that amounted to that. I mean, suppose the Fees Office official rejects the MP's claim for expenses, and the MP is aggrieved, and the MP goes to the Fees Office and he racially abuses and threatens the official. Again, are the appellants really suggesting that this would be covered by privilege? One can multiply the examples. One more, which is the one given in argument yesterday, very helpful if I may say so, by my Lord Mance. Suppose the MP has his lunch in the cafeteria in the House of Commons every day, and the waitress gives him the bill. And suppose he dishonestly amends it to reduce the amount, which he then pays at the till. Now, the appellants could not seriously suggest, I submit, that the MP is immune from prosecution, that privilege applies, because the House of Commons cafeteria, no doubt, is answerable and regulated by a committee of the House of Commons, which approves the prices, approves the procedure for payment, and so the alleged conduct can be said to be linked to the performance of parliamentary functions. Of
course, these examples are not coupled with the declaration which you see at page 115 addressed to the validation team against the knowledge that the information that is provided on the form will be used for administering and accounting for members' estimates and so on and so forth.
Yes,
I mean, the thing is linked into the process of obtaining money for the purposes of the core functions of the Parliament.
But one could in the cafeteria example, one could have a system by which the MP signs for what food and drink he has taken, and there's a rubric. You know, I hereby certify that I have indicated on the form the amount of food and drink that I have taken in accordance with the published price list. One could have such a system. I don't accept that rubric can possibly make the difference in identifying the answer to the question whether or not the performance of the function in issue in this case, which is the completion of the claim form, is sufficiently closely connected with the functions of the Member of Parliament such that privilege applies.
Well, one can't ignore the declaration. I mean,
I don't
it's there
suggest
for
one
a
can
very
ignore it.
obvious purpose, to make it absolutely clear to the individual signing it that this is an important document, and it's a document which lies at the heart of obtaining money from the Treasury, no doubt, to enable Parliament to perform its functions.
And I accept that the money is paid by way of expenses because the Member of Parliament has performed parliamentary functions. But the issue in this case is whether the act which is indicted, the detail of the claim form, is the filling in of the claim form, is of itself more than an administrative act which is sent to the official for administrative dealing, or whether it is, as the appellants have to suggest in my submission, applying the authorities, in itself, that is the filling in of the claim form, in itself the performance of a core function of the MP. And although it's linked to the core functions of the MP, it is not in itself a core function of the MP.
There would have been nothing inappropriate, would there, if the IPSA had decided, well, we're going to adopt this claim form in the same form?
I respectfully agree. The IPSA could have proceeded by reference to such a system, undoubtedly so. And in those circumstances, privilege would not apply, in my submission. Now, my friends, Mr. Fleming and Mr. Fitzgerald, each suggested that if criminal proceedings could be heard in this context, there was a real risk of rivals of members of Parliament making false complaints. Well, this is, with great respect, unrealistic. It's unrealistic because Mr. Fleming and Mr. Fitzgerald accept that members of Parliament are subject to criminal proceedings for a whole host of alleged criminal acts, both in the Palace of Westminster and outside. And there is ample scope for the rival to make false complaints, if that's what he wants to do, whatever the answer to this case. There was then an argument, I'm turning to the points made by my friend Mr. Fleming, there was then an argument by reference to the Joint Committee's findings on the scheme for registration of members' interests. And my friend Mr. Fleming pointed out that the Joint Committee suggested that the scheme for registration of members' interests is or should be covered by privilege. The court will remember it's in the Joint Committee report. I don't invite you to turn it up unless the court wants to. Volume 5, tab 49. It was paragraphs 119 to 124. But, my lords, the register of interests is very closely connected with the free speech rationale of Article 9. The whole purpose of the register is to enable people to know whether the Member of Parliament has an interest when he speaks in Parliament or otherwise contributes to the work of Parliament. In any event, the committee did not consider the width of the privilege in this context, and it is, and my Lord Lord Brown referred to this yesterday, it is very difficult to envisage a criminal offence in relation to the register other than criminal conduct which involves speech in the chamber. And those were the examples that my friend Mr. Fleming gave, the Member of Parliament who talks up a company in a parliamentary debate, so increasing its share value without declaring his interest. That, of course, is within the free speech, well within the centrality of the free speech rationale of Article 9. There was then a reference to the fact that the Members' Estimate Committee of the House of Commons took the view that because parliamentary privilege applies, Members of Parliament could not appeal to the courts against the decisions of Sir Thomas Legge on repayments of expenses, and therefore the Members' Estimate Committee decided MPs should have an opportunity to appeal to Sir Paul Kennedy. Can I invite the Court, please, to look at why Parliament took this view? It's volume 5, tab 59. This is the statement from the committee. They tell us at tab 59 that they've agreed to recommend to the House that any overpayments identified by Sir Thomas should be repaid by MPs. They expect that members will voluntarily repay any sums found to have been overclaimed. Before this happens, the committee believes MPs should be given an opportunity to show in an independent process any special reasons why it would not be fair or equitable in their particular case to require them to make the repayments. That's the appeal to Sir Paul Kennedy. This process is designed to reflect the opportunity an individual would have in legal proceedings to show why he or she should not be required to make restitution. That opportunity is not available to members in this case because of parliamentary privilege. And then they explain the process they've set up with the appeal to Sir Paul Kennedy. And they say at the end it's going to be completed early in 2010. Its outcome will be published by the MEC alongside Sir Thomas's findings. Sir Thomas's report will be published in full with all his findings, even if there are cases where Sir Paul recommends that a repayment should not be made or should not be made in full. Following publication, the committee will seek a resolution of the House authorising the recovery of any outstanding payments. So what we have here is a decision of the committee, the MEC, to adopt the findings by Sir Thomas and, furthermore, the intention of putting those findings, as amended by Sir Paul, to the House itself for a resolution. It is quite inconceivable in all those circumstances that the courts would accept that they have jurisdiction to challenge the findings of a report which has been adopted by a committee of the House and which is going to be put before the House itself for approval. None of this assists the appellants in the present appeal. There's also reliance on the test suggested by the Joint Committee at paragraph 129. Could we go back to the Joint Committee report at paragraph 129? It's volume 5, tab 49. It is perhaps important to note that it's page 38 of tab 49. Paragraph 129, what they're recommending is the enactment of a definition on the following lines. This is not the drafting of a precise statutory provision that will deal with the sort of problems that we have been addressing in the present case. It's a proposal which would be subject to scrutiny, pre-legislative scrutiny, and then scrutiny of the House. And it is, in my submission, unlikely in the extreme that a joint committee which was so concerned to ensure that privilege was narrowly confined, as I've shown the court, that it could have contemplated that any document that was sent to a committee or to an officer should, for that reason, enjoy privilege. That part of the report does not assist.
But once the document is accepted, is suggesting that a requires some kind of higher status, doesn't it? Otherwise, what does this mean?
One can understand that there would be, in the standard circumstances of the case, that the committee of the House of Commons is considering a difficult problem and it invites people to submit evidence to it. One can well understand in the standard case that those who submit evidence which addresses the topic of the committee's deliberations, those documents would enjoy in the normal course of event a privilege. But to suggest that that's dealing with all cases, particularly cases of the sort we're dealing with now, would conflict with the approach that the Joint Committee itself adopted in the passages that I read out, that one must be very careful to confine privilege to that which is truly necessary to enable Parliament to perform its task as a legislative and deliberative assembly.
Just before we leave this bit,
yes.
Just the last few lines of 125, paragraph 125, we're back to the written code of conduct.
Yeah.
Just read the St. Roston Edwards. I mean, does this written code of... We haven't got it, apparently, have we?
I don't think it's in the bundle of documents. Of course, the court will be provided with it.
Yeah. I mean, does it touch on anything to do with expenses?
I can't answer that question because I don't remember it.
We've got it if you want this copy.
Does it touch on expenses? Can we look at that?
Of course.
I don't want to give you the I simply don't know the answer.
Well, Frank, doesn't the reference to documents in paragraph 129 have to be read in context of the previous few pages, where it's really talking about correspondence, drafts to committees and so on? It's inconceivable that it could be really referring to a document of the kind we're...
Well, I was I'm great.
You get the same sort of flavour, I think, from the page 100, which is Appendix B. You see the Australian formula.
Yes.
Just line with what Collins says.
My Lords, my friend Mr. Fleming then says that if the system of expenses were different to that which it actually is, and oral statements were made to Parliament on the floor of the House of Commons, privilege would apply. And similarly, he says, if the procedure involved an oral statement or a written statement to a committee of the House, then privilege would apply. Well, of course, the difficulty with that argument, as the Court of Appeal noted at paragraph 74 and 75 of its judgment, is that that is not the system. And we are here concerned with a sliding scale, necessarily a sliding scale, where the closer one comes to the relevant document, the relevant statement being made in Parliament itself, or being part of the committee's deliberations, the stronger, obviously, the argument for parliamentary privilege. And I repeat, there's a very good reason why the procedure for expenses is not, as in my friend Mr. Fleming's examples, it is dealt with as purely an administrative matter, whereby the document goes to the official, precisely because it is an administrative matter, and it is an administrative matter, although linked to the performance of core functions of the MP, the claiming of expenses is not of itself a central or core or essential function of the Member of Parliament.
Just going back to the previous discussion we were having about contractors and the like.
Yes.
That's addressed, I think, in paragraph 246 onwards, where they discuss the need for a dividing line. And
They
indeed,
do.
some of the points we discussed are governed by a statute. But they say at the end, it's not a tidy problem, or not a tidy...
This is 248. Indeed, so.
248, the boundaries
And
are
at the
tidy.
end of 248, they distinguish between resolutions and orders, which are proceedings in Parliament, and I accept that, but their implementation is not, and I would respectfully agree with that as well. We are here concerned with implementation and not with the content of resolutions and orders. My Lords, I noticed the time.
Yes, we'll adjourn until 2.
Thank you very much.
We've got some sandwiches in the